Hello everyone, my name is Nabil. I am part of the organizing committee for the 11th annual Cambridge International Law Conference, and I welcome you to today's panel on protecting human rights. We have a fantastic lineup of presentations and some great academics here who will be presenting. Just to start off, I would like to introduce our chair for the panel, Mr. Raghavi Viswanath. Mr. Raghavi Viswanath is a Ph.D. researcher in international human rights law at the European University Institute. Her doctoral project tries to re-articulate cultural rights using vocabularies and grammars from the global south. And alongside this, she is also a consultant for cultural rights collectives in the Indian state of Tamil Nadu, a senior research associate at the Public International Law and Policy Group, and a visiting lecturer at the National Law School of India University and the University of East London. I would now like to hand it over to Ms. Vishwanath to get this panel started. The floor is yours.
Thank you. Thank you, Raz, for that really flattering introduction. Good afternoon, I guess. Good morning, also good evening to everyone, wherever you're tuning in from. Firstly, thanks so much for taking time out of your weekends to join us for this panel of the 11th annual Cambridge International Law Conference. My name is Raghavi Viswanath, and it gives me great pleasure. It's an absolute privilege, in fact, to be able to chair this panel on protecting human rights. Before anything else, though, I must thank my dear friend Tejas Rao and Jane Quinn, the conveners of this conference, for thinking of me and inviting me to chair. This panel, as I'm sure many of you would agree, cannot be more timely. Every second now, perhaps more than ever, wherever we look around, whether it's in Ukraine, in Russia, in Afghanistan, Jamaica, and also closer home in our micro ecosystems, in our own families, in the transport we use, or in the websites we access. We are constantly confronted by how the reality of, we're constantly confronted by the reality of how fractured rights models are, how deeply political, oppressive, illusory they are, but also how relevant, ever-changing, and pervasive they are. Often, though, crucial questions of human rights get drowned in the rhetoric and the chaos of invoking rights vocabulary in public discourse, which is why, at least to me, a session like this today, where we can take a second to pause, to think together, and to learn from each other is imperative. Today, we have the opportunity to learn from and hear from four exceptional scholars who will be speaking to us about a wonderful diversity of issues, I think. I, for one, do see some commonalities in the selected topics, perhaps courtesy the organizers. So today we will hear about conceptions of global security in international law, on the role of global governance in potentially bolstering insecurity, on hate speech and incitement to genocide, and the proceduralization of speech regulation, hate speech regulation by internet platforms. That said, it gives me great delight to introduce you to our speakers, our panelists for today. I will introduce them all at once and in the same order in which they will speak, both as a reminder to myself and them. First up, we have Dr. Sophie Durva. Sophie is a postdoctoral fellow at the KFG Berlin-Potsdam Research Group on international rule of law, rise or decline, where her research focuses on the governance of global security in international law. Sophie obtained her PhD in law at the European University Institute in November 2020. So she is an inspiration for someone like me who is still on the other side of the line. Sophie holds an LLM in public international law from Leiden University, where she graduated cum laude, and an LLB from the University of Essex and University of Paris, West Nanterre. Her first book, entitled The Regulation of Intelligence Activities Under International Law, is forthcoming with Edward Elgar Publishing. Welcome, Sophie. Next up, we will hear from Dr. Maxwell Young-Ju, who is an associate professor at Prince Mohammed bin Fahd University. Maxwell is an SJD graduate of American University, Washington College of Law, where he wrote his dissertation on the principle of proportionality in the law and ethics of war. Prior to joining the SJD program, he taught at Sungsil University. He was a legal and policy advisor to a representative of the Korean National Assembly and also a researcher at the Supreme Prosecutor's Office of Korea. Thanks so much for joining us, Maxwell. Next up, we have Dr. Isabel Lischewski. Isabel is a postdoctoral researcher at the University of Münster in Germany, where her work focuses on questions of global governance, access to justice, and empirical legal studies. She studied law at the University of Münster and Higher School of Economics in Moscow. During her doctoral studies, she also spent a year as a visiting researcher across the Atlantic at New York University. Her thesis, Lawful by Design, Measuring Procedural Justice in Global Governance, was recently published by Cambridge University Press. Thank you so much, Isabel, for joining us today. Finally, we are joined by Mohammad Khalid Rahman, who is an assistant professor of law at the American International University in Bangladesh. He earned his LLB, LLM, and MSS in Criminology and Criminal Justice from the University of Dhaka in Bangladesh. His research interests include public international law, human rights, law of the sea, and terrorism, amongst others. He has been a practicing lawyer since 2009. Notably, he's also worked with the Bangladesh Legal Aid and Services Trust. Today, he also identifies as a photographer and a filmmaker, having recently made a film about the persecution of the Rohingya, which is an issue he will also be speaking to us today about. The format we will use today will be as follows. Each of our panelists will speak for 15 minutes, and I promise to be strict with time. This will be followed by a discussion segment. In this panel, we have decided to play around with the discussion segment. So we will club it with what was supposed to be a question and answer segment. What we will do is we will spotlight each paper, and for a duration of 5 minutes, we will seek comments first from the panel itself and then from the audience. So do feel free to use the Q&A function to pose questions to the speakers, perhaps also with a short introduction of yourselves. I will keep an eye on them and ask them for you. From what I know, I don't think there are any other housekeeping instructions for me to issue, which is a signal that I should stop speaking now and hand over the virtual floor to our first panelist, Dr. Sophie Duroy, who will speak to us about her submission titled The Case for a Human Rights Approach to Global Security. Over to you, Sophie.
Thank you, Raghavi. As usual is, I'm sharing my screen. I hope you can all see it well. So good afternoon, everyone, and I'm delighted to present this paper today. Contrary to appearances, it is rather normative and very theoretical, so I hope you won't be too disappointed. But in this paper, I try to change the way that we think about security in international law. It's still very much a work in progress, and I welcome all types of feedback, questions, and comments in the Q&A or later by email if you wish to do so. So the starting point for this paper is the empirical situation. We are facing more and more challenges that have global effects, and we can think very easily about climate change, terrorism, wars, obviously, migration or pandemics. But we commonly frame these challenges as national security threats. So that is, we adopt a state-centric frame when speaking of and addressing these challenges, and this remains true even when we speak of international or collective security. And when we do this, we overlook the connections between these challenges. We overlook their interdependence and their influence on one another, and their effects beyond the states, on individuals, on ecosystems all around the world. So we know that no state security apparatus is able to tackle all of these challenges by itself. And we know that it's not only national security that is at stake, but we keep addressing these challenges within the parameters of national or international security. And this is where the ethics of security cosmopolitanism become relevant. So security cosmopolitanism seeks to ensure that security is available to all humans and ecosystems equally, and that the security of one state, group, or environment is not purchased at the expense of another security. Security cosmopolitanism builds on critical security studies, but rather than advocating for doing away with the concept of security, it proposes a rehabilitation of security through its reconceptualization as global security. That is, a global, structural, and non-anthropocentric understanding of security. And global security rests on 3 ethical principles. The first one is global security responsibility, which refers to the responsibility of all states to create deep and enduring security for all human beings. The second principle is future security responsibility, And it refers to the responsibility of all states towards future generations to consider the impact of their decisions, choices, and commitments through time in order to ensure the long-term integrity and survival of ecosystems. And finally, we have the global categorical imperative of security, which globalizes Immanuel Kant's categorical imperative, and it is formulated as follows. All states and security actors bear a responsibility to act as if both the principles and consequences of their actions or policies will become global, across space and through time, and to ensure that their actions will have positive consequences that can be borne by the world as a whole. So in this paper, I aim to translate these three principles of security cosmopolitanism into international law. And what I seek to do is to find ways to make global security a reality within the existing international legal framework. So in order to do so, two moves from the current state-centric security paradigm are needed. The first one is a move from a mainly military approach to security to an approach based on fundamental equality and human dignity. And the second move is one from the security of the state to global security with humanity as its referent object. So in this paper, I make the case for a human rights approach to global security on pragmatic, ethical, and legal grounds. And I argue that providing global security is already a legal obligation of states under international human rights law. So in other words, a normatively strong human rights approach to global security, coupled with appropriate global governance, has the potential to achieve global security as defined by security cosmopolitanism. So before I come to the conceptualization of global security in international law, which is the core of the paper, two sort of preliminary steps are needed for it to be more than a simple ideal. And first, I need to make the case that it actually benefits national security to respect human rights and to comply with international law. And I need to do that for states to be able to see their interest in making a change towards global security. So I have 4 points there. And the first one is that global challenges are so interconnected and interdependent that, as I said before, no state security apparatus can face them by itself, which means that international cooperation is needed. Second point is that short-term aggressive security moves actually aggravate security threats and they decrease the possibilities of cooperation. So if, as a state, I conceive of national security as a zero-sum game, then I seek to increase my own security at the expense of other states or non-state actors. But them being less secure will actually make me less secure too. So it ends up being counterproductive. The third point is that empirical research shows that human rights and rule of law compliant policies yield the best results. And conversely, drastic, authoritarian, or discriminatory policies are counterproductive because they only aggravate the conditions conducive to security threats. So what works best to address these threats, according to empirical research, is to focus on the protection of human dignity. So for states to place the rule of law and human dignity at the core of their security policies is right not only in principle, but also pragmatically for them to protect their own national security. And the final point here is that accountability and backlash, which are to be expected, are determining factors to enhance compliance because they change the costs, payoffs, and incentives of engaging in extralegal security policies. So the risk of accountability acts as a protective factor for both human rights and national security at the same time. The second preliminary step is that I need to find a framework for ethical decision-making that can reflect the principles of security cosmopolitanism without requiring fundamental changes in the structures of the international legal order. And for this, I rely on Kantian ethics in the paper, but due to time constraints, I won't go into details here. If you're really interested, feel free to email me and I will send you the paper. So now moving on to the conceptualization itself. So in this paper, I make the case that placing the dignity of the human person at the core of state security policies when facing global changes is not only pragmatically and ethically sound, but it is also a legal obligation of states. So in this sense, international law embodies at least the first principle of security cosmopolitanism, that is global security responsibility. And I start my conceptualization by defining global security, answering the 7 questions that you see on the left of your screen. And I will spend most of my time here on question 2, security for which values, because this is where I try to operationalize global security in international law. So I hope you will excuse the sometimes brief explanations and the occasional lack of justification for some of the questions. But going in order, security for whom? So following security cosmopolitanism, achieving global security implies securing all bodies, biomes, communities, structures, and systems that connect humans and ecology everywhere and through extended time. So in short, we can say security for humanity, but humanity understood broadly. Second question, security for which values? So a cosmopolitan ethics of security requires that the core values to be secured for humanity are fundamental equality and human dignity. and other values to be secured, which correspond to the multiple dimensions of security, all derived from fundamental equality and human dignity. So enhancing global security in the current international legal order means relying on its existing security actors, namely states, and the norms and structures of international law. And to states, providing global security means providing all humans everywhere with security for their dignity as human beings and preventing harm to other life forms in doing so. And human dignity can be operationalized in international law through the notion of essential and inviolable cause of universal human rights, which are the one or more essential elements of a right that are not subject to limitation or exceptions. So in other words, the core of a right guarantees dignity to its beneficiaries. And the idea here is that a human right formulated in broad and morality-based terms would constitute a principle in the meaning of Robert Alexis' theories of rights when positivized in law. But this right would at the same time carry a narrower rule as its essential and inviolable core. So the core or essence of a right can therefore be conceived of as a rule within a broader principle. And unlike principles, rules do not allow for optimization through weighing and balancing. They apply in an all or nothing fashion. So conflicts between rules are resolved by either applying one rule with the result of rendering the other invalid, or by applying a valid exception to a rule. So the essential core of a right forming a rule is therefore inviolable in the sense that it cannot be compromised, and restrictions to it are impermissible. No weighing or balancing with competing goals, rules, or principles is allowed. The essential and inviolable cause of rights have priority, and they must be realized fully and immediately. So the notion of core essence of human rights allows us to operationalize the security of human dignity in international law to the matching obligations of states that we tend to call minimum core obligations. So by identifying the core of human rights and states matching minimum core obligations for all universal human rights, we can translate into legal obligations the protection of human dignity. And in this sense, minimum core obligations legally safeguard the security of human dignity. I unfortunately cannot spend too much time on this, but I hope that these brief explanations are somewhat clear already. So moving on to question 3, how much security? So here I argue that the necessary amount of security can be defined by reference to the minimum core obligation attached to each human right, so that only when the essential and inviolable cause of all universal human rights will be respected for all human beings everywhere, will the whole of humanity have enough security. From what threat? So in this paper, my normative commitment is to security cosmopolitanism. So I take the liberty to say that the threats are those that threaten human dignity and therefore global security. And these threats fall broadly within 3 categories. The first one is man-made physical violence. The second one is natural and biological threats. And the third one is threats that result from complex overlapping causes, such as economic crisis or migration. And I want to make it clear here that classifying these issues as global security challenges is quite different from securitizing them, because here the implication is not that they require the exercise of extraordinary powers, but the opposite. They should be addressed through compliance with international law and international cooperation. So providing global security implies securing fundamental equality and human dignity while facing these challenges in a lawful and cooperative way. And this brings me naturally to question 5, which is by what means? So by what means should we provide global security? So as I just said, security in the face of these global challenges should be provided through respect for the international rule of law. And I know this represents a clear departure from the assumption that security is or should be provided mostly by military means, but it does correspond to the findings of empirical research that highlights that long-term security is best achieved through human rights and rule of law compliant behavior. So finally, the last 2 questions. At what cost? So providing global security through respect for the international rule of law is already a legal obligation of states, which are bound by international law. So to states, compliance comes at the cost of renouncing short-term national security objectives that are incompatible with their international legal obligations, such as the unlawful use of force or discriminatory measures. And the perceived trade-off might be high for states, but objectively, what I'm arguing is that their long-term national security will be increased. And finally, in what time period? So achieving sustainable global security should and is a long-term goal. And the challenges faced are complex ones, and they should be addressed through lasting solutions and programs and not through quick fixes. But both emergency relief and longer-term actions can be needed at the same time. So the limit here is that short-term action should never compromise or undermine long-term global security. So finally, coming to the conceptualization itself, global security can first be conceived of as a multidimensional universal good. And multidimensional here means that global security encompasses For instance, physical security, economic security, environmental security, cyber security, social security, and many others. And global change is often threatens several dimensions of security. And insecurity in one domain can further affect other dimensions of security. So this interconnectedness and interdependence mean that there's no abstract hierarchy between the various dimensions of security. They all matter, and they are all required to achieve global security. And this means that prioritization should never have the effect of decreasing security in some dimensions in order to increase others. On top of that, the various dimensions of security reflect the values protected in that they correspond to one or more cores of universal human rights. And if each human rights includes one or more essential cores, then there is no abstract order of primacy between human rights. So recognizing human rights as interdependent and indivisible is a precondition for realizing global security in all its dimensions. And in turn, we can say that global security itself is indivisible in that it is only achieved when all its dimensions are adequately preserved. Second, global security can also be conceived of as an objective of progressive realization, in the sense that while its full realization may be achieved progressively, steps towards this goal should be taken immediately and be deliberate, concrete, and targeted. So conceiving of global security as such means recognizing that states have an immediate obligation to make progress towards its full realization. And in this sense, minimum core obligations represent the means to the end that is global security. So with full respect for the essential and inviolable cause of universal human rights, human dignity is secured and global security itself can be progressively achieved. So in conclusion, because I know I'm running out of time, conceptualizing global security as existing legal obligations of states or to both states and individuals opens new paths for enforcing these obligations in international legal order. It also enables the design of regulatory interventions aiming to effectively hold states to account for breaches of these obligations, focusing especially on the role of human rights obligations. And to bring this closer to reality, the next step of my research will focus on the governance of global security as a global public good in order to identify paths to provide it effectively. But for the moment, that's all for me. Thank you very much for your attention, and I look forward to your comments and questions.
Thank you, Sophie. That was such an excellent presentation. Next, we will hear from Dr. Maxwell Young-Chu, who will speak to us about his paper titled The Passion of Global Governance as a Threat to International Law, the Irreversible Precedent of Libya and UNSC Resolution 1973, Legitimizing Illegality under Humanitarianism and Democratic Interventions. The virtual floor is yours.
Yes, can you all hear me? Hello?
Yes, we can hear you.
Okay, thank you. So I'll set my timer to 15 minutes. And thank you, Sophie, for your presentation. And I think my paper touches upon the notion of which values and by what means you presented in yours. Okay, the title is pretty long, Passion of Global Governance. Everyone is talking about global governance. This entire presentation and our conference today is about global governance. But what concerns me is, what is global governance? We talk about it. We've been talking about it for the past 20 years, but what is it? So first question I'm raising is the absence of definition. So what exactly is global governance? And this absence of definition fuels problems that threatens the very ideals of global governance and even threat and destroy the rule of law. One of the problems that we face will be the fallacy of generalization. If one global governance principle, let's say in economics domain, applies, then everyone believes that it can apply to the human rights sector. It can apply to the national security sector. But I think it's not. Because of the absence of definition, we fall under the fallacy of generalization. And also, global governance, I think it's a very evolving concept. When it first began, I think it began mostly with economic bearing, but now it touches upon all aspects of human society. But once again, if it's evolving, then why are we not putting into phases? So that's another aspect of the ambiguity of global governance. And this ambiguity goes into this indifference to use of force, interchangeable use of global governance and democratic governance. And especially the concept of democratic governance is what concerns me the most, because it just opens the door for countries like the United States, France, the United Kingdom. On the other side, I don't know, like Russia, China, to bypass existing international law under the phrase of this democratic governance to exert its political influence on other nations, infringing all types of, what do you call it, international existing regulations. So this is the starting point of my question. The ambiguity of global governance, the definition itself, is the product of where we fall into this trap of subjective discussions, where everyone's rationalizing everything because no one really knows what they're talking about. So with that in mind, I'm using the case study of Libya, and the scope of this discussion is narrowed to the military force, use of military force, or use of force, whether it be cyber, kinetic, drone, whatever. But so why Libya? 2011 Libya, we all know that it's a prime example of R2P, responsibility to protect. That's what all the scholars and everyone's been focusing on. Libya sounds like a success story, but I believe Libya sets a very dangerous precedent, especially in a discussion of global governance under the argument of democratic principles. Second is that in the study of law, it's critical that we find similarities and differences. And one thing that Libya is very different from Russia and Ukraine, because Russia and Ukraine are two sovereign states, and it's a war or a conflict among the two states, but Libya was an internal conflict. So we can't apply Libya to Russia and Ukraine, or use Ukraine and Russia to learn about Libya, because the nature of the conflict itself is very different. So remotely close would be North Korea. So Libya, if you want to study a case study, I think it should be looked towards North Korean issue rather than the current Russia and Ukraine. So what's the problem with 2011 Libya intervention? It's all about the UN Security Council 1973. There was nothing global about this. Everyone's championing it's a birth of R2P. It was a birth and a success of international cooperation. But when you look at the text of the UN Security Council 1973, and if you look at the aftermath of the intervention, the NATO-driven US-led intervention, there was nothing global about this. It just raises a lot of problems and questions. So what are these problems? There are two sets of problems. The first set of questions are threat and violation of rule of law. So Afghanistan, Libya, if you look back, why did the US or Western-driven powers intervene? It was all under this notion of democratic intervention. So states are now using global government as a reference to use democratic principles as an initiative for their foreign policy. And I see this as a very concerning threat, because it's a new birth of American and Western imperialism. In the past, imperialistic approaches captured land, used military forces, but today they're using these ideal or ideological rationalizations to bypass existing international law to exert its political initiatives. Second, Libya is a prime example of where, although there is a UN security resolution, the reality, so there's a discrepancy between the law and reality where, yes, UN sanctioned, UN security sanctioned resolution, yes, use of force, NATO force, but if you look at the text and the actual reality, there is a discrepancy to the point of being illegal. And finally, whenever you use global governance or use principles of global governance, especially on the democratic values, you always run into a inevitable conflict with the treasured notion of national sovereignty. Yes, political debates of whether you're going to be a realist, relativist, cultural relativism, it's beyond the scope of legal argument. But legally speaking, when you're using global governance and democratic ideas, we do have to address the question of what we're going to do with national sovereignty, because it is a principle that is treasured. So these are the bunch of problems pertaining to rule of law, what we see from Libya. And if you go to the microscopic aspect of UN Security Council Resolution 1973, if you look at the text, first, everyone uses this as a champion to R2P, but the problem is that the entire purpose of this Security Council was to prevent imminent atrocities. Now, this reflects the Bush Doctrine, 2001, after 9/11. We know the Patriot Act. We've seen how the United States have articulated the notion of preventive self-defense. So you're defending before, so self-defense argument goes beyond the scope of this forum, but still the concept of using military intervention to prevent imminent atrocities, that should raise and flag some concerns, because what is imminent? Second is Article number 2 of the Security Council resolution. It says, stresses the need to intensify efforts to find solutions. Okay, fair enough. But what happened in Libya? Brazil, India, and South Africa demanded that we needed more time. We have to discuss this. NATO and US, France, and England said no. The African Union was planning to visit Libya. They said, hey, let's go in. We'll send representatives. We'll talk to Gaddafi. But NATO, US, France, and UK said no. So Article 2, it says exhaust all efforts, but there were suggestions by these countries and these unions, but apparently that didn't really go through. So possible violation of Article 2. Article 5, it's the scope of the Security Council 1973. It says protect civilians and civilian populated areas under attack. So the target is civilians and the geographic area is populated areas under attack. But NATO, what did they do? It was all about overthrowing the Gaddafi government, 2011, October, and replacing the government itself. So there's a confusion of governance and government. So if you look at the second set of questions, so the first set of questions dealt with the general public international law. If you look at the second set of questions, it goes into the text of the Security Council itself. Now, with this in mind, why the problem? Why do we have all these problems? Okay, I put them into 3 different categories. One is this menacing clause of all necessary measures. So necessary measures. What is necessary measures? We've seen this in the Patriot Act, all necessary means. So this repeated clause, all necessary means, all necessary measures, is a regular phrase under UN or government mandated military actions, but no one really knows what all necessary measures is. Also, there's a problem of, that's definitional issue. Second problem is everyone's confusing the jus ad bellum and jus in bello principles, especially necessity and proportionality. So we need to clarify this. The third is it's giving birth to the victory of the political arguments, democratic system, democratic values, democratic principles. It could be legal, but it's political. So a lot of states, especially Western-driven states, are using political arguments under democracy or democratic principles to bypass existing laws or bypass the ambiguities of law. And why? this is a problem for today. Our forum is that we are talking about global governance. Global governance is a what do you call it? It's a universal trend. But I see this. What I see, the biggest problem concern about global governance debate is that, as I said in my first page, is that we're falling into this fallacy of generalizing the definition. So yeah, with this in mind, possible solutions. Now, the first solution is defining or avoiding the use of all necessary means. This opens up the doors to actions that can be articulated and supported to be correct by the aggressors. But so let's prevent that from happening. So all necessary measures. Let's try to be more direct and limited or exhaustive in its definition. Number two, UN Security Council. We all know that it doesn't work. So maybe look at Article 31 of the UN Charter to raise question about the veto powers, or maybe look at the General Assembly Resolution 377 or the rule book, the rule of procedures of the General Assembly to restore the balance of power among the member states of the UN, because UN is a byproduct of World War II. And we see, especially in the realm of international security issues, it's not working. It's bipolarized. And so why is everyone keeping silent about this? So maybe we can dedicate our efforts to reforming this. Third, so whenever we go into global, or whether it be international law, international governance, global governance, everyone talks about the absence of a global government to enforce these regulations. But let's try to think outside the box. What about having ad hoc tribunals? Because we are talking about security issues, we have the Nuremberg trials, we have the ICTY, ICTR, we have many success stories. So it might be more plausible. It's going to be costly, but if we are looking at the long term, and if we are approaching this from the perspective of restoring rule of law into this global governance discussion under the rim of national security and global security, maybe ad hoc tribunals are the only feasible answer for the time being. And finally, comprehensive efforts should be made into categorizing and redefining global governance into this, like different phases and categories. So we have, for any international phenomena, it evolves. And I think we do have to take into that consideration that global governance is a very broad and comprehensive, but evolving concept. So we do have to put that into perspective and apply it to our understanding of using global governance as an initiative in addressing global security issues. So I think I spent 15 minutes and 10 seconds. This is what I had ready for today. If you have any questions, please feel free to ask me later on. Thank you very much.
Thank you so much for your presentation. Also for sticking to time, both of you. It's making my job as chair easier. I also particularly enjoyed the line you were drawing between democratic and global governance. I think we'll have opportunities to explore that, juxtapose that with Sophie's paper later in our discussion segment, which I'm looking forward to. Next up, we have Dr. Isabel Lischewski. She's going to speak to us about her paper titled Designing Oversight, Overlooking Human Rights, How State Interest Shapes Procedure in Platform Governance. So over to you, Isabel.
Yeah, here I am. I'm sorry. Here I am. So thank you very much. Thank you for having me on this panel. I really appreciate also the diversity of perspectives that we have seen so far and that we will continue to see, I think. So the paper that I submitted for this is obviously actually too long to present in 10 or 15 minutes. And it covers a lot of background that I will only briefly refer to here and kind of give the most important pointers and focus on the case study, which is probably the most interesting part anyway. But I want to start, if this will allow me. It will not. Yeah, it will. By actually with this picture, and I actually appreciate also the direct segue from Maxwell's paper talking about what is actually global governance, because this is basically the picture that a friend of mine who was not an international lawyer at all or political scientist came up when I presented her with the concept for my dissertation. And I really like it because the juxtaposition kind of this kind of more rigid, more geometrical matrix-like web or net or whatever you want to call it, and the, let's say, more organic shape of the circle behind it, for me, kind of represents this multi-layered structure of global governance that we have, and both and not just global governance as an actual phenomenon, but also of the study of global governance, and shows both the overlap between different perspectives and between different aspects of global governance, and the kind of the excess of meaning that we get, the lack of connection sometimes between different concepts, or the missed connections that we find here. And so for me, it also represents kind of the opportunities and dangers of trying to approximate these relationships in any meaningful scientific research, which is nevertheless exactly what I will try to do now. So I started out on this building on kind of the scholarship that was, I think, actually already mentioned in one previous presentation and previous panel, that studies more the relevance of procedure within global governance, notably global administrative law, which looks at how this kind of advent of more procedural rules in global governance, maybe how it came about, what is meaning, can we compare it to administrative law principles that we know from our home jurisdictions. And my approach was trying to figure out why these procedural rules, which I do conceptualize also as procedural justice, emerged. And in order to do that, I stole and developed, or some would say mutilated, some concepts from the theory of institutional design as we find it in international relations theory. So based on all of this, on the theory of institutional design, and on this perspective that we do find more, or that we do observe more procedural rules emerging in all these different kinds of global governance institutions, which obviously not only consist of classic international organizations, but which also include all kinds of private or hybrid, or even harder to conceptualize actors. I did theorize and then also was able to show that we have a higher density of such procedures wherever this procedure is used to safeguard sensitive state interests with regards to whatever this global governance institution is doing. And so because then there is an interest on behalf of the states on having kind of more means of control, on creating transparency within this institution. And here I can also echo another point that was made, I think, in the first panel today, that we do see a kind of indication that here procedural justice is preferred over outcome justice, or that at least there's this juxtaposition where if institution designers can't agree on what would constitute outcome justice, then they will prefer to instate procedural justice, and this will usually be seen as also sufficient to safeguard state interests specifically. And then, of course, if we are looking at global governance, which consists to a very important part of, let's say, private actors, although I do want to add that it's very hard sometimes in this, especially in the sphere of global governance, to distinguish what is actually a private actor and what is more of a state-run actor. Of course, we have to also show that this could also be the case for private institution, where maybe the kind of the avenue for state interest is not as obvious as it might be for international organizations. But there is also very interesting evidence from other fields of political science and studies that do show how state interest or government interest can influence self-regulation by private actors who will choose to introduce certain measures to avoid and to maybe make themselves look better, or to make governments be content basically with the rules that are in place. And there are certain requirements maybe to have that, is that the rules have to have a certain quality, let's say, but then this may often be the reasons for private actors to actually introduce similar rules than those that we find in more obviously state-run institutions. Now, I wanted to look, this is the kind of the procedural justice part, but then I wanted to look at whether this has any influence at all on the outcome justice, because there is kind of you could kind of have an intuition at least that there is some kind of connection between input and output, especially with regards to the human rights aspect, which is obviously something that does not play a role in this previous part of the observation. And for this, I also wanted to look more at the private actors, which are of course very powerful. And this is where the case study of the Facebook Oversight Board, or of the Oversight Board as it's now, with the rebranding of the corporation, kind of now called. So just very briefly, maybe for those who are less familiar with the Facebook Oversight Board and what it does, it was established by Facebook itself, or by the Meta company itself, which holds, among others, Facebook and Instagram. And it consists of independent experts in different fields. It was the initiative started a few years ago, and it took up work in early 2020. And what basically happens is that we have this issue of content moderation at Facebook, obviously, where there's now an internal system in place to review content that has been flagged or identified by an algorithm, and then to say whether this, for example, constitutes hate speech and therefore violates the Facebook guidelines. And because this is a very sensitive process, obviously, and it has a lot of implications, both politically and with the human rights or legal perspective, the Oversight Board is kind of the last resort where either Facebook can submit difficult questions, which it does more rarely, but also users who are affected by a content moderation decision can give this to the board, and the board selects questions based on whether it finds that these are difficult and especially relevant to basically the operations. So for the case study that I wanted to do, I wanted to look at all the 23 decisions the board has made so far, 23 cases, especially regarding the recommendation that the board issues in each case. So the board does make a decision on whether the individual content should be basically be accessible again or should be removed forever. But more importantly, I think it gives recommendations based on this case regarding what we should learn from this, what Facebook or Instagram, how it should revise the community guidelines or something like this. So the thing that I wanted to do, or that I did, was to look at all of these decisions and to say whether the recommendations, first of all, are themselves more of a procedural nature or of a material nature. So whether they directly affect more the kind of the process of content moderation, whether they add, for example, other steps, or they say that the way the user has to be notified should be changed in any way, or whether they refer to the material content of the guidelines that Facebook uses to moderate content, for example, regarding what constitutes hate speech, what can be exceptions to hate speech, so very typical, also human rights questions, basically. So I wanted to see what the relationship between these two types, and there might be more than two types, but let's suppose there are two, of content moderation recommendations are. And the second thing that I wanted to do was to look at what kind of hierarchy the Facebook Oversight or the Oversight Board gives to the principles that it applies to these cases. Per its charter, the board applies 3 sets of standards. The first 2 are basically Meta's internal values and content moderation guidelines. And the third one constitutes human rights, which are applied via the United Nations guiding principles on this, which Meta has voluntarily accepted. So I wanted to see if there is a conflict between these 3 sets of rules, if, for example, one of them supports, in this case, deleting a certain post and one supports keeping it up, how this kind of conflict would be solved by the board, and therefore to be able to see kind of what the material content here is maybe going to be. So regarding the first question of the procedural versus material recommendations, there are many methodological issues here that one could raise, and I did find it not easy to always distinguish what would be a material or procedural recommendation, but even leaving aside many coding issues that could come up, I do find that there is quite a strong indication that the board issues more procedural than material recommendations in most cases. And when looking at the individual cases, selected cases, one does also see that this general trend seems to me to be even stronger in the very high profile cases. So the most high profile one probably being the one regarding the restrictions placed on the account of Donald Trump following the January 6th Capitol riots, but also other cases, for example, regarding issues having to do with Israel and Palestine, where the recommendations to me seem to be especially geared towards avoiding kind of a political character and focusing more on the procedural aspect. So this does support to me the idea that was a question, that the idea of this procedural over material recommendations, and also the idea of procedural justice over outcome justice does persist. And although this is definitely not a detriment from a human rights perspective, because obviously procedure and proceduralization of speech regulation can be also important tool in human rights protection, this does, to me, raise the question whether the material development of the guidelines will be stalled or will be slower because of this, for example. And there also seems to be, furthermore, a certain deference to Meta's interest as a company to not interfere too much with the interests, the sovereign interests of states, not offend kind of their sensibilities, and overall to maybe keep a more neutral image with regards to very sensitive political questions, although this, of course, always in flux. Regarding the second question of principal hierarchy, there are only 2 cases so far that in which the board actually had to kind of make a decision because it could not get all 3 standards to agree. And in all of these cases, kind of the human rights sets of standards came out on top, and it was very clear that this is the one that the Oversight Board considers supreme. And furthermore, because this is, of course, only 2 cases, when we look at those where the board did not find that there was a direct conflict between the 3 principles, where according to these 3 principles, there would have been different decisions. But even if all of these came to a similar decision, we do see that the board very strongly in its recommendations models the guidelines for which it makes recommendations after human rights, after very established precedents from human rights and very established human rights jurisprudence. And this is also just something that is also supported by statements from individual board members, which have said numerous times that the board strives to generally raise the level of human rights compliance of the meta community standards, and kind of that this is actually the overall standard that it sees. So even one could argue kind of a even constitutional type moment, if you wanted to have that discussion, so that it uses human rights also as a kind of a benchmark against which Meta's internal principles are measured. So as we can see, the 2, so we have a kind of maybe a tension, or at least not a very one result leading in one direction or the other. So we do have a perpetuation of this preference of procedure over outcome. I think we can see that very clearly. And again, this is not overall problematic, but this does show that there is a certain goal or a certain idea of maybe depoliticizing global governance. On the other, the board itself, I think, is very clearly, as an individual, as an institution, kind of regarding its self-image, it is a value-driven actor. Whether you want to say that this is opposed to Better as a company or just stating it neutrally. So this is also something, and giving the board this power, whatever may have been the kind of the motivations behind this, may also lead to the board slowly instituting some kind of inner institutional change. So there's also violence to be seen, given the fact that the board has not been active for this long. And this is actually also, I think, where I want to make the connection again to Maxwell's presentation, because I think also the juxtaposition of these two findings call us to look at global governance and human rights actually with a tolerance for ambiguity, which is a phrase that I like actually a lot, and an understanding of the complicated and reciprocal relationship, especially between, on the one hand, self-interest, self-preservation as a driver of procedural justice to be preferred, and on the other hand, values and the human, and not to juxtapose this absolutely, because again, these two are not mutually exclusive, of value-driven politics and human rights. So I think this already concludes my remarks. Yes, thank you. I look forward to your questions.
Thank you. Thank you so much, Isabel, for your presentation. And I in particular enjoyed the visual start and the constant visualization along with your presentation. It really helped me ground the case you were making. Next up, we have Mohammad Khalid Rahman, who's going to speak to us about his submission to the conference titled A Study on the Persecution of Rohingya, Considering Incitement to Genocide on Global Standards, an Empirical Approach. The floor is yours.
Thank you very much, Madam Chair. Am I audible?
Yes,
am I audible?
Yes.
Thank you very much. Thank you, Madam Chair. So before starting, the slide, I just want to share something about my country. That in 1971, the people who fought valiantly against the West Pakistanis, and they declared independence on this day, the 26th March. So today in Bangladesh, we are celebrating the Independence Day of our country, and I'm glad for the people, those who fight for the independence of our country, and that's for the reason I'm presenting my country, my university in front of everyone. So today I'm going to share my study about the Rohingya persecution, especially connected with incitement to genocide, hate speech, and I have conducted this study based on actually two types of research, which is actually in the first part. My the concept of incitement to genocide and the connection between hate speech and incitement to genocide is actually based on qualitative research, and then after that, I just want to substantiate my findings into quantitative ones. So that's why I use both qualitative and quantitative research. So let us jump to the objective of this paper. So the purpose of this paper is to explore that speech with the incitement to genocide, which is actually a crime initiated in Genocide Convention. And during the systematic and recurrent brutality, extortion, torture, and persecution of Rohingya minority in Myanmar committed by the Tatmadaw. Tatmadaw is actually the military of the Myanmar and the Rakhine Buddhist community by evaluating data and Rohingya victim evidence. So these are my research questions I am actually working for. How may Rohingya are victim to the incitement to genocide? What are the causes of the hate crime that occurred in Rakhine? What are the purposes of hate propaganda? What are the regions inciters used to initiate hate propaganda? And how social media has been optimized to spur the hatred against Rohingya? So let us jump to the hypothesis. Actually, I have initiated 4 hypotheses, which is first one is connected to hate crime, connection between hate crime and incitement to genocide. Then how Tatmadaw hate crime, and what are the actual reasons. So in my thesis, I found out that the religion and ethnicity, which is actually, they call it Danghantia, that is the Myanmar ethnicity or the son of soil, which is actually connected with the reason for persecution, and the reason that the Rohingya people has been, disconnected from the Myanmar people, and then incitement to genocide has been spread through different tools of communication, especially Facebook, and we'll find out eventually that how the Facebook has spurred the violence, and we already know that some Rohingya people there have already filed a case against um, Facebook for claiming $150 million damages. So we'll eventually go through it. So I told you earlier that I have used two types of methodology. One is qualitative and another is quantitative. And for quantitative research, I used a structured questionnaire method to collect data from Rohingyas, and I found 383 Rohingya who have agreed to talk with us about the hate crime and Rohingya persecution. And I actually use Likert scale for quantitative research, quantitative survey. So let us jump to my first part, which is actually describing about the public threat and public incitement to commit genocide. So this concept, threat and public incitement to commit genocide, is a part of the 1948 Genocide Convention, and along with other 4 crimes, which is now very essential and connected to hate speech, according to my research. And though the incitement to genocide is a legal concept, but the convention doesn't give any definition of the said term. And besides, the convention also made the term more rigid by adding threat and public. However, whenever the people they are conducting the draft of genocide convention, there were actually 3 drafts of genocide convention, and in the first and second draft, there is no saying about or adding the words threat and public. But unfortunately, from different states, contexts and their perceptions, they have added the word threat and public, and finally they have included the term threat and public incitement. However, the trial court in the Akayasu and Masuhuko made observation on the term threat and public incitement. As such, threat and public incitement is strictly provoking the perpetrators to commit genocide, whether through speeches, shouting, or threats uttered in public places or at public gatherings, or through the sale of dissemination, offered to sell or display of written materials or printed matter in public places or at public gatherings, or through the public display of placards or posters, or through any other means of audio-visual communication. So you can see that the prosecutor versus Akayasu, this is the first case where ICTR has, said that to someone for incitement to genocide. And actually, the most popular known case as the media trial case, which is prosecutor versus Nahimana et al., but the Nahimana case, which is actually saying that the incitement to genocide is how much connected to it the hate speech. And then in the Kambanda case, it said that the leader of Rwanda's caretaker government during the genocide, John Kambanda, and upholds the notion that no one is above the law when it comes to incitement to genocide, including heads of the state. And another, in Bikindi case, the Simon Bikindi was a popular singer in Rwanda, and his allegation of direct and public incitement to genocide was based both on his songs and 2 speeches he gave over a vehicle's loudspeaker while traveling. So I told you earlier that Nahimana case actually is highly connected with the hate speech or hate propaganda. So in this segment, I would like to show the connections or relationship between incitement to genocide and hate speech.
Mr. Khalid, I am so sorry to interrupt you, but I don't think we can see past the first slide on your slideshow. If you could reshare your screen to the PowerPoint, to your current slide, I think we'll be able to move on from there. Because right now all we can see is your first slide. So if you can just reshare your screen, yeah, that should work.
Okay, let me share the screen with you again. So is the screen visible to you?
It's just the first slide again. If you can share the PowerPoint presentation rather than your desktop, I think that may be the issue. So if you could just check that.
Okay, I'll try
I think it's
to
fixed.
share. It's fixed now?
Yeah, we
Is
can
the
see.
screen visible to you?
Yes.
Okay, okay,
Apologies for
I'm
that.
extremely sorry for that.
No
Okay,
worries.
okay, so I'm actually talking about the relationship between incitement to genocide and hate speech, and how much the Nahimana case is connected with the incitement to genocide and hate speech. The trial chamber stated that the hate speech in a certain context can amount to incitement to genocide. So it further clarified that media that fosters hatred, such as RTLM, can be held reliable for incitement to genocide. Thus, prosecutor versus Nahimana laid the foundation for the prevention of propaganda leading to incitement to genocide. And then Radoslav Rajurin concluded in the Radoslav reference to vermin and scum and his calls to kill Muslims really sound like Ferdinand Nahimana's statement about immunity or cockroaches. So in the last slide, we have discussing about how the cultural context is connected whenever the people they are using the cases or the words against the particular group of people. So eventually, I have included this perception in my quantitative survey. But however, the necessary link between speech act and context in international criminal law is still unclear because, but under some context, we can still say that these incitement to genocide or hate speech is very much connected. Is actually based on the understanding of the code and how the cultural context is connected within the intention of the people. Let us jump to the next slide, which is let me share some factual, cases, examples that how the causal relationship between speeches and the subsequent public violence are connected. In 2001, violence broke out in Etongu division, reportedly after the distribution of these pamphlets by the USD, later USDP, and the violence reportedly left around 200 Muslims dead. Especially the killing of Ma Tida Hadwe in 2012. After the killing of Ma Tida Hadwe, raping and killing of Ma Tida Hadwe, there is sparring of communal conflict between Rohingya Muslims and Rakhine Buddhists. And in Tongab, the Rakhine Buddhists had killed more than 10 Muslims in a bus. And again, another example is that the RNDP issued a statement on June 26, warning of the threat posed by current Bengali population and called for a final solution. The RNDP likewise applauded Hitler, arguing that inhuman acts were sometimes required to keep a race together. And again, in the Kalimanjaro case, I told you earlier that we are going to go through the cultural and linguistic context. And here are some examples how the Rakhine Buddhists, they have used the mentality about the Rohingya Muslims. They utterly said the Rohingya Muslims that they are Bengali illegal immigrants, they are illegal Bengali, they will swallow us, they sneak into the country, and also they have used that Bengali extremists, terrorists, criminals, and rapists, the jihadists. So you see, they're always using the word against these Rohingya about the against the ethnicity and against their religion as well. Uh, there are there are few more examples I actually connected with these issues, but actually I guess that I have time constraints, so I will just to skip these slides. And I just want to add one thing that I told you earlier, that any kind of audio visual communication is highly connected with incitement to genocide. And I told you earlier that Facebook post, the use of Facebook, especially in this persecution, has so much prevalent that it actually caused a lot of problem, a lot of issues while the Rohingya actually in Myanmar. So in a post, Facebook post, it has been said that these moth color, the Rohingyas actually called moth color. The moth color getting his foot in the door in Myanmar politics is not something we should sit by and watch. We need to do something right away. So that is the post which has been shared with Facebook, and the post received over 800 reactions, 450 shares, and 60 comments. And these informations have been connected by me in the IIFM report, and so there obviously are lots of informations and examples about this. Now, let us jump to the analysis from the study, from the empirical survey, which I have been conducted. So I told you earlier that I have conducted research on 393 Rohingyas, and the demographics are here: 60% male, 39% females, and the age groups. And sorry. And you can see the victims who have been suffered from hate speech. They are 70%, and witnesses are 30%. And my first question was that there were systematic participant and intentional incitement against Rohingya, and they agreed on the point, strongly agreed on the point. 83% people strongly agreed on the point. And then the Tatmadaw government officials and the Buddhist ethnic groups are the inciters. They also said yes, and strongly agreed 76% people. The inciters dehumanize Rohingya people, like they use equated the Rohingya with animals, vermin, insect, and diseases, etc. And you said earlier that yes, they have been using this kind of words earlier, and yes, they agree with the statement. And then the inciters managed to convince the Rakhine Buddhists that the Muslims are endangering the Buddhist character of the nation, especially the religion. So yes, they also said yes, and then the racial purity, which is ethnicity, and here another the people strongly agreed. 40% people strongly agreed, and then the the different types of communication tools have been used for spreading hatred, which is they agreed 73% people, and then social media has been used, and the people say that 62% people have said yes, they are using up this kind of social media. So these are my findings. The Rohingya community is a victim of systematic incitement, which is both pervasive and deliberate. Hate speech, propaganda, and assault towards the Rohingya community, of all which are linked to genocide incitement. And then Tatmadaw and the extreme Buddhist community are claimed to be perpetrators of bigotry and propaganda against the Rohingya. The inciters are clearly using religion to incite the Rakhine Buddhist population, and it has been discovered that various newspapers and electronic media, particularly social media, play a significant role in sparking enmity with the Buddhist community and the Rakhine community. So that's it. Thank you very much for your questions. So over to you, Madam Chair.
Thank you. Thank you so much, Mr. Rahman. That was a fascinating presentation. I think made even more poignant by the fact that it falls on the occasion of Independence Day. So thank you so much for sharing it with us today. All right, with this, I guess we move to the discussion segment. Perhaps we can pin all the panelists, which I see Raz is doing now. So like we promised at the start, we'll go from paper to paper. We already have questions pouring in for all of you. So good news on that front, but perhaps for the people who have read the whole drafts or who had access to the whole drafts, we can give all panelists a chance to share comments or give feedback or really just raise points for rumination. And I'll try to chip in whenever there are silences, I think. So we can first start with Sophie's paper. Right, so I'll now open the floor out to co-panelists. We can go in the order on my screen if all of you already know which questions you have, or feel free to raise your electronic hand and I can call on you. And hopefully we can flood Sophie with questions, given that the point of this was meant to be more workshop-ish. Do we have questions already? Maxwell.
Okay, thank you for your presentation, Sophie. You had a lot of information, but going back to the very two questions, which values and by what means? So you use the notion of equality and human dignity as a solution to depart from our reliance on military, if I'm getting the point correct. And you discussed in depth about security, cosmopolitanism. But my question to you is that, yes, this is a question that I'm always having, but equality, human dignity, all good. No one's going to say no to it. But two questions. One, human dignity, how you're going to overcome the subjectivity of relativism, especially for a person like myself, educated in the West, teaching in an Islamic state. I'm very careful as to what is right when it comes to human dignity, because, for example, human dignity, maybe the right to education is a given right to some countries, but for some, it may be not. Because of their religious, socio-political reasons. So how are you going to overcome that subjectivity? And number two is, you said when there's in part of your presentation, when you talked about legal obligations, you said there is no compromise, there is no exceptions. But there is going to be a conflict. So if there's no compromise, how are you going to resolve that situation? This is a question that I'm always facing. I don't know the answer to, so I'm asking, it's difficult, but I'm asking for your insight or just to see what other people are thinking about this notion, because theories and ideas and values are right, but it's very difficult to translate them into reality. And yeah, my question's there. Thank you.
Thank you, Maxwell. Do we have other questions from the panel? Perhaps while all of you are thinking about your questions, I can also add one for Sophie. I think it relates to what Maxwell said about relativism. So, of course, one part of this is the fact that the content of human rights changes depending on which ecology it's being applied in, which ecology it's being experienced in. But I think a lot of this also has to do with who's determining these epistemologies. So it's not just whose values, but who says whose values. And this is a question I've often asked myself when I read about Kant's cosmopolitanism, which is the fact that we always speak of universality, we speak of cosmopolitanism, but it always carries Western grammars and comes at the cost of exclusion of lots of other grammars. So I was wondering how this idea of global security can actually bring in more grammars, more epistemologies into onto the same plane, into mainstream discourse. Sophie, maybe we can take a bunch of these questions already, and then I'll source more questions.
Okay, so should I start answering? Is that what you meant?
Sure.
Okay,
sure.
thank you. These are challenging questions, but really good ones. Questions that I've been thinking about for the past few months. So the first one, how to overcome the subjectivity of relativism and what's right when it comes to human dignity. So my point here, and I think it links with your question, Raghavi, is that the state doesn't get to define what is the dignity of its subjects. So in this way, it should come to each person to define, what is dignified for them. But so my way of contorting this issue, because obviously it's really hard, and I don't pretend to tell people, what is their human dignity and what they're worth of, what is their worth as human beings, is to basically say that we have this kind of core, this core into rights that at some point you cannot go further without infringing on the dignity of any person that you can think of. And this is the one thing that cannot be compromised or that we cannot have exceptions on. And sometimes it's the whole right, such as for the prohibition of torture, for instance. Then the whole right is the core of the right. But sometimes it's a very, very tiny part. And it has been referred to by certain courts or tribunals, such as when the European Court of Human Rights in a case against Switzerland said that at some point, the essence of the right to privacy is infringed when we are criminalizing the right to beg of a person by basically preventing them from surviving. And there we come to the essence of a right. So I think this is where we come, and this is not for me to determine. I think this is for courts and tribunals, and this is where we can have some regional particularism and for kind of adaptation to local and cultural specificities, so that it doesn't become this Western imposition of standards. I also think it's for each and every one of us, to know where the limit is, where we don't feel like human beings anymore, and maybe this means that we are not secure in our humanity. So yeah, this is my issue, basically, that I don't want to be the one to define it, and I can define the by what means, or also which challenges, and then I can say that I have a normative commitment, and this is the choice I'm making. But for human dignity, I rely on the core of human rights and universal human rights, all of them, but it's not for me to define what the core of these rights is. So I kind of pass the burden onto courts and tribunals, and they have started doing it by referring to the essence of the core of certain rights. So I'm hoping that we get to determine more and more what these cores are. As to legal obligations and the compromise and how to resolve in case of conflict. So this is why I'm referring to Robert Alex's theories of rights. It has been translated not by me, by Bitterbuck, into international law. And the thing here is that if we can differentiate properly between rules and principles, then we know how to resolve a conflict. This was a whole PhD thesis. It's going to be published soon, so I'm using it here as my theoretical framework. So principles, we compromise between them, and we make sure that both can apply as much as possible for the facts of the case. But rules, we don't compromise. So if there is a rule on a principle, the rule takes over. And it's very rare that there are actually two conflicts between two different rules. Most of the time, one will apply and the other will not, and it's not a real conflict. So if we go through all the methods for resolutions of conflict, there's no real conflict. So if we're talking about the core of human rights, I haven't found a situation where there would be a conflict where the essence of a human right would be involved against another essence of human rights, or against another rule, and one wouldn't have priority. So I'm hoping this helps this, but yeah, if there are any other questions, please feel free to come forward. And I hope I answered this.
Thank you, Sophie. I must also second you here and say that Sergey's work on rights and principles and how they interact is really illuminating. I've had the chance to read that, and I'd recommend everyone else to do so as well. We have some audience questions, so maybe I can intersperse some audience questions while we're having this discussion. I think we have one question from Yusuf Hassan, who's from Morocco, and he asks whether in a world of data-driven surveillance, it is credible to think that people know their own minds and act in their own interests. I guess this relates partly also to Maxwell's point about subjectivity. And we have another question from the audience. This is from Andrew Koo, and I guess we can address it to you. He asks, how do we address the violations of human rights when they're committed in the name of protecting national security, which often can turn into a euphemism for political ends? I do think that there is a common thread of, what do we believe? How do we not know that it's just being used for rhetoricization? So perhaps if you'd like to address them, we have the time for that.
Yes, I mean, I can start with Andrew Koo's question. And this is why I'm arguing and advocating for a move from national security and the security of the state to global security, so that we can consider the security interest of actually actors at all levels. So individual states are the kind of global community, but also ecosystems, and introducing more security interests than just protecting the government, basically, or the executive, rather than even the people living in the state. So how do we address this? As I would say, violations of international law mostly. But yeah, as I said, this is a very theoretical paper. I will move on to the kind of practical implementation of it, but I'm not sure I can answer all the questions about how to implement it yet, because this is a very normative and idealistic idea I've had, and trying to make it become a bit more realistic and less up in the sky. But yeah, I would say by changing how we think of national security, and mostly how we think of security in international law, that it doesn't only mean national security or international peace and security or collective security, meaning only the security of the state, and very little and very rarely the security of its people and the people that inhabit the earth. And for the other question, so I have it in the chat, in the world of data-driven surveillance and psychographic, that people know their own minds are acting in their own interests. How can that touch respect of human rights? Well, if there is interest in that, I would direct everyone to behavioral international law and behavioral law and economics, basically, about all of our biases, even without data-driven surveillance. Well, yeah, this is a message I really like, but all the cognitive biases and heuristic that we use, in our daily lives, but also in law, and how that affects the respect of human rights. I think this is a good question. Probably the research hasn't been done yet on the impact of our cognitive biases and heuristics and the respect of human rights. But yeah, that's a good question to ask. I'm sorry I don't have an answer though.
Thank you. Thank you so much, Sophie. For everyone else who has questions for Sophie, do reach out to her. I think she's already shared her email address and you can reach out to her privately if you have questions about the paper. I guess this is a signal that we should now move to Maxwell's paper, also about solutions, implementation of global governance approaches, of course, in the context of the R2P doctrine. So first, again, I'll open the floor out to the panel. If any of you have questions, I know that there were lots of interrelated threads, interrelated substantive threads. So if you have questions, maybe this is the time to shoot them to Maxwell. Isabel?
Yes, thank you. As already indicated in my own presentation, I do appreciate, and I think this is something that maybe I should self-critically also kind of include more into my own focus on global governance. You pointing out that there is actually, that global governance is not just because power is more distributed or more diluted, is not immune to power imbalances and bias, and that it can be used as this kind of ideological justification that is meant to hide more direct interests. I do wonder though, because you also pointed out, and of course we have a different view on the ambiguity of global governance and its risks or its opportunities. And so anything that you would want to state more, maybe in how far you would also see an opportunity that lies within the malleability that you also point out, the evolutionary nature of global governance, and how far it could actually, if used correctly, maybe also actually help those things that you are also criticizing. And also I was wondering, and in relation to this, because you did also point out I think the legalization of political problems, or wanting to distinguish the legal from the political. And this is obviously something that also is related to what I am trying to do. But the question that I always ask myself is when we do look for these legalized forms of political problems, whether we are actually solving the problem or hiding the problem, and what this transfer of the political question to the legal question, or the even trying to distinguish the two, is actually helping or hindering a solution.
Okay, thank you very much for your question. And not to get anything wrong, so two questions. Number one, I am not against global governance. So I think the purpose of our conference was to be a little critical about global governance and where we headed. So we can be popping up our champagnes and celebrating that, oh, this is how much we have reached. But the reason why I went to the extreme and use Libya as an example is that, yes, there are benefits behind global governance, and I think it's an inevitable phenomenon that we can't depart from. It's like internationalization, globalization, then global governance. So it's a process. But we do have to pay attention to that there are a lot of issues that we often neglect due to the fact that we are championing global governance. So we're moving forward, but at the same time, we're taking that burden with us without actually solving them. So, and this is limited to, I know there's global governance have made great progress in the economic sector, the environmental sector, and so forth, but relatively compared to the military sector. But all in all, the common factor is the US. It's departing from that environmental corporation. It's walking down on its own path for its military. And that's the same with China and Russia. So it's global, but we have all the global superpowers exempt from these efforts. We have the Europeans jumping in, we have Asians, we have all this. But I think the reason why I'm raising these concerns is that to be really global, it's not about the number of participating states, but actually how we can translate these ideals into reality. I think that somewhat clarifies. So I'm not against global governance, I support it, but I was just raising questions about it. And I think that moves on to the next question of legalization and politicalization. Yes, it's very difficult. Sometimes it's both sides of the coin. But what I see behind the inevitable limitation of a political driven effort is that superpowers will always win. They will always have that upper hand. And I think the law is our arsenal and a democratic systems where everyone's equal, whether you may be the richest country in the world or you may be the poorest country in the world, but you still have one vote. That's why we do have to bring in this legal structural framework. It's going to take a while. It will take time, but we have to continue rather than speak of the ideals, go back to that founding principles of international law, where every state, sovereign states have one vote, one saying, and they are equal. I think that can only be restored when we focus more on the legal aspect rather than the political. That's why I'm trying to like complicate the issues or make it unreal, but that's the way I think it should go. Law is the only arsenal that we have to make every country equal, have an equal vote. And only when we have that understanding, we can realize true global governance in its diverse sense. I hope that clarifies or answers your questions, Isabel.
Thank you, Maxwell. I wish I were as optimistic as you when you said law is the only arsenal we have. I'm not there yet. It's going to take me some more convincing, I think. More questions from the rest of the panel. I know we have lots of audience questions already, so perhaps I can ask them away. We have one question from Swan Jin, who's an LLM candidate at the University of Edinburgh. They've asked, you spoke of ad hoc tribunals offering pragmatic solutions to the problems you identified in relation to global governance. And the question is why the choice of ad hoc tribunals over perhaps a permanent court? I guess this also relates to issues of fragmentation, which feels like international criminal law often.
The reason why I spoke about ad hoc is that I think the reference, I don't know where we can see the Q&As, but I think she's referring to the Roman statute, ICC. But two points. One, yes, Roman statute, ICC, excellent tribunals, but reality-wise, US not a member, Israel not a member, China not a member. So if you look at all these, I wouldn't say more critical, but if you look at headline news events, these are the key actors, United States, Israel, and China, and they're not there. They're immune from that system. Also, second factor is that I know a lot of papers have been dedicated to sending the leaders of North Korea to ICC. It's been said and published 20 years ago every year, but no one has stand on that court. So, and finally, if you look at the proceedings of the ICC, they're penalizing leaders of African nations only, I think. I don't know. We have, those don't make the news headline. We don't know what's happening in Congo. No one really, unless you go to BBC World, it's not headline news worthy. So the reason why I'm speaking of an ad hoc rather than the ICC is that ICC, we had this for a long time. And I don't think it's working. The idea is there, we have the institution, but realistically, is it doing its job? I don't think so. Maybe 10, 20 years later, I may come back and say, oh, I'm sorry for making that comment 20 years ago. But as we stand now, I think it's not enough. That's why I recommended that ad hoc rather than the permanent ICC.
Thank you, Maxwell. There are a couple of other questions for you relating to the R2P doctrine and its scope, but I think we have to move on to Isabel's paper because we are operating with a strict timeline. Thank you so much for engaging with all of those questions. So Isabel's next. Questions from the panel. Sophie has a question already.
Yes, thank you for both the paper and the presentation. I found it really interesting. I'm wondering if at some point you are making any sort of normative assessment of the Oversight board. And I understand that you're saying that procedure is preferred over content or substance in a way. But I'm wondering, what is the risk of the oversight board being an interpreter of human rights, whether in procedure or in substance? Especially because I don't think they have, or the oversight board or Meta has human beings' interest at the core when they draft both the procedural rules and the substantive rules, and when they say we need to take into account human rights, they mostly have capitalist interests in mind. And states, you know, also they want to keep states happy so that they won't establish their own tribunals or push it further. So what is kind of the risk of the private influence on human rights standards? And I don't know, to me, it seems quite dangerous thing, whether it's even if it's only on the procedure, the fact that they have the right and the possibility to interpret human rights standards or digital human rights, however we want to think about it. Do you make a normative assessment of that? And what's the difference then between procedure and substance in a way? And maybe how could we counter it? If I can add just another question. Thanks.
Should I go directly or should we? I can go directly.
Works actually. Oh, Maxwell has one question, or maybe more.
So thank you very much for your presentation, Isabel. Very interesting. I'm not a very what you call it, Facebook, Instagram person, so that meta concept was very intriguing. But the question I have is that I think that procedural aspect it's a solution. I think, but going back to the question I had, going back to the question I raised to Sophie, is that when you materialize this, are you going to be doing it? So once you have that theory, you are going to try to put it into reality. So are you going to do by a country incident, or are you going to do, how are you going to implement this in reality as it? So I want to see your vision of how this theory unfolds in reality, so that the principles and ideas and suggestions that you made actually works. Does that make sense? Okay.
Yeah, so I think I can actually take these two together. Maybe I think that fits really well. So, and I think that because this, I think, applies to both of the questions. I'm not primarily making a normative case about this issue, of course, also regarding whether, you know, procedure is good or bad, actually, but more regarding the fact that the thing that I can kind of see from my research on this is that this procedure, because it is instated with objectives in mind that are not primarily achieving achieving meaningful normative progress in a sense, or the fact that the way I conceptualize procedural justice actually is more focused on what is perceived as procedural just, which is what states, or in this case, will see as a process that they will accept the result of, for whatever reasons and for whatever normative or other concerns that they may have with this. And so I think, so this is why I'm also not really, I think in Maxwell's sense, suggest
I have lost Isabel. I don't know if that's the case for everyone else. I see nodding heads, so we've definitely lost Isabel.
I cannot hear her.
I think we can wait just a few seconds and
Yeah, let's do that.
connectivity, and if not, we can just move on to the next question, and then
Sure.
back we can address the question.
Sure. Thanks, Raz. In the meantime, though, I'd invite all of you to populate the chat with questions for Khalid, Rahman. All right, Isabel's dropped off. We can give her a couple of extra seconds to see if she's able to talk back, and maybe.
Yeah, I think we can just move forward, and then once she's back, we can continue with that question.
Thanks, Raz. All right, let's move to Khalid Rahman's paper, which was an excellent paper. I thought a lot to ruminate over. Questions from the panel. Sophie?
Yes, thank you for your paper and for the study. I found it really interesting. So I'm wondering if I get everything right. Is basically your study was trying to show that the overlap between hate speech and incitement to genocide is almost total, whereas this is not what the law and what the case law say. Did I understand this right? And then maybe could you say a bit more words about what you see is the difference basically between law and practice in this overlap between hate speech and incitement to genocide? Thank you.
Should I go for the answer? Or?
Maybe I can add one more question. I see Isabel's back, so I want to indicate to her that we moved on to Khalid, but we'll come back to you for the remainder of the questions and the answers. So Khalid, I had another question for you, which two questions actually. One about your empirical choice not to interview Rakhine Buddhists. So I could see that you spoke to Rohingyas, but I was wondering whether there is some value in also speaking to Rakhine Buddhists to understand how they've perceived these purported calls. That was number one. And second, about given that a lot of this incitement, like you also mentioned, takes place over social media platforms, whether perception of intention, whether the standards you would apply for perception of intention, you see them changing, you see them perhaps becoming stricter because of the fact that it's on a social media platform. So I would like to hear your thoughts about this as well.
Okay, thank you for a question. I'd like to address the first question asked by Sophie. So you guessed it right. Actually, what I was trying to do, like I was to, combine how the the court has seen the incitement to genocide within the aspect of its speech. And I don't know yet whether this is a very fruitful manner to compare with the court decisions with the hate speech conducted by Rakhine Buddhists towards the Rohingyas. But I have tried my level best, because the one thing which has been given in the Nahimana case, the court observed that the context is very important. So the thing is that if we have gone through the anthropological history of the Rakhines, these actually are a part of the Bangladeshi region right now in 1600. So they are somehow connected with the aspects of the relationship between the Bangladeshi people and the Rohingya people. So they are somehow connected, like the Kolkata people in India. They are connected with our with us. So you see, what I have tried to do, that I would like to analyze the context, which is pretty much connected with the hate speech conducted by the Rakhine Buddhist. And I don't know yet whether this is actually a procedure, whether I have succeeded or not. But for that reason, actually, I have used the case references, especially the Nahimana case in the ad hoc trial. And the question that had been asked to me by the chair, that actually it's a very solid question, and actually I should have included it in my limitation, because you see that the almost 10 lakh Rohingyas right now residing in Bangladesh, and it is not easy to reach there, but it is not impossible for me, for a Bangladeshi people who are actually working on research on Rohingyas earlier. So it's not impossible but it's difficult. But for the Rakhine Buddhist, yes, it's actually a limitation for me. I agreed on that, but I have tried on several occasions to, visit Myanmar or to reach a Rakhine Buddhist, but it is actually impossible for me to conduct the quantitative survey, which is actually based on, a lighted scale. I guess that if I know 2 or 3, Rakhines personally over Facebook, from Facebook, but actually including their intentions or answers would not be sufficient. I guess in that case I must go for the qualitative approach, which is actually on one-to-one interview or open-ended question. So I will obviously think about it. Thank you very much for your question. I guess that may answer your questions.
Thank you. Thank you. Definitely did. Do we have any more questions for Khalid Rahman? Perhaps while we are waiting for those questions, we can go back to Isabel, who's now managed to log back in. So Isabel, I think we heard you to the point where you were answering Maxwell's questions.
Yes, I'm sorry.
You managed
I
to
hope
say
this will
that
not
you were
happen
not
again.
making innovative. Yeah.
So yes, I think so. I wanted to get back to also Sophie's other question regarding the risk that is entailed with tasking a private organization with this. And I think what that we actually see is the tension between the oversight board as a sort of perceiving itself as an independent actor, I think, and its actual being reliant on Meta as the company who established it and finances it, just on a very basic point, and also who makes the rules about what happens at the oversight board. So I do think that we can see within the individual acts of the oversight board, and also looking into the decisions and the way that they are written, that there is a very genuine effort being made at applying human rights very, very faithfully, and a lot of reference being made to case law and to, for example, general commons, etc. What we do, however, see is, of course, the reliance on Facebook. And the very interesting case for this is also the Trump case again. There we have the issue that the board will ask both the individual who is affected by a decision and the company for kind of their will ask them questions, and they can submit like lists of questions to Facebook. And in this case, it's submitted about something like 40 questions to Facebook, and Facebook does choose to answer not all of the questions. So the interest and the questions that they did not choose to answer, aside from like not interesting ones, relate mostly to the Facebook algorithm and in how far the algorithm, for example, would push content such as kind of this level of speech that Trump was putting at this point, and also regarding how the kind of removing certain posts would affect the company financially. So there are very clear red lines into how far Facebook is willing to cooperate with the board. And since the board cannot do like a contempt of order, a contempt of court order or anything, or you know, have a deposition or have any kind of more enforcement power towards this company, it just cannot answer these questions. Therefore, it cannot make recommendations, for example, based on knowledge about how the algorithm works. And this is a very weak point. And it's one of many criticisms that has been leveled against the board as an actor. So this is definitely one of the limits that it has. But I do think that here the problem lies less in how the board kind of thinks about human rights and the decision that it makes, and more in how it is embedded within the structure of obviously a profit-seeking company. So I think, and again, of course, there could also be if the board had different members who had a different understanding of their job, there could also be issues in another way, because there is not really any protection against it. Just as it is functioning right now, I do not see the big problem within the decisions that are actually being made, and more in those that the board just cannot make because of factual constraints.
Excellent. Thank you so much, Isabel. Maybe I see that we can afford to take one more minute. So one last question out of pure curiosity. And I know that this wasn't really what you were investigating in the paper, but perhaps I was wondering if you could speak to us about whether there are differences in the extent of reliance Facebook seems to have placed on jurisprudence or precedent in procedural decisions vis-a-vis outcome-based decisions.
I cannot say that I think it does rely more for the kind of the material recommendations probably on the ethics in case law, just because the case law will often relate to this, because the procedure is usually, I think it's actually an interesting point that could be added to the paper. The procedure is often very specific to Facebook, so there may not be a lot of case law regarding if a person should be notified in their own language when their post on Instagram about using certain substances is being removed. I think this is the procedural recommendations are often more specific to the situation at Facebook, so that might be just one very practical reason why this is not a thing where they can refer to a lot of case law. But of course, it does influence how the procedural standards then then turn out because they are not influenced as much by the human rights case law. So that's a good point.
Yes, that's exactly what I was trying to get at. All right, I see that we are almost on time, and I think we have to let our audience go so that we have a break before the next panel. Before I leave you, I think I should invite everyone to thank you for your incredibly interesting presentations and for taking out the time for engaging with all of these questions so patiently, so generously. And I'm looking forward to reading full versions of the paper, possibly in print. And I encourage everyone to also reach out to our panelists privately if you have more questions, if you want to pick their brains about something you wanted to ask. I think that's all from me. Thank you so much again. Thanks to the organizers for being an incredible support throughout this panel. I know there are lots of times when I was reaching out to you on private chat, so I really appreciate the support. And have a good rest of your day, wherever you are. Thank you.
Thank you.
Thank you.
Thank you
Thank
so
you,
much, everyone.
everyone.